In this video, we are going to be looking at the law of contract, but then more specifically, we are going to be looking at offer. I will be taking you through the definition of what amounts to a contract under statute law. We will also look at the essentials of a valid contract, and then I'll also define for you what offer is. But then we're also going to be discussing together the rules governing an offer, and also we'll be looking at the rules governing revocation of that offer, and then finally we'll be looking at the termination of an offer, also known as the modes of terminating an offer. Hello there, my name is Mutiawa Conrad. I am a lawyer and a private law tutor. And before we start on our class, I encourage you to ensure that you have subscribed to my channel. This is really important to you because every time I release videos, this will always be brought to your attention. Please don't forget, turn on the notification and also proceed to click on the subscription button. It's just below your phone, and if you're using a phone to watch this video, just put it in landscape mode. Then you'll see a red button coming in the lower right hand corner, or there is a button somewhere there. Just click on it and subscribe. And then finally, students that are interested in private law tutorial sessions, please feel free to reach out to us. Our numbers are down in the description box. Contact us, call us. We can always make a private arrangement so that we're able to help you improve your grades and to appreciate these legal principles a little more in detail. So let's jump right into our subject today. And as we said, this class is mainly about the law of contract, but more specifically, we are going to be covering offer generally, and we are going to unpack it inside out to look at the principles governing it, the law, the various cases. We're going to be discussing a number of principles, both under statutory law and also under case law. But let's now start by defining a contract, because you can't jump into an offer without first understanding what actually amounts to a contract. So I encourage you to look at the definition of a contract under the Contracts Act of 2010. Under section 10 subsection 1, it specifically attempts to define what a contract is. And when you read under that section, it provides that a contract is an agreement. So that's point number one. It is an agreement made with the free consent of parties with capacity to contract for a lawful consideration and with a lawful object with the intention to be legally bound. Now, please, if you're reading this section, you have to ensure that each of those aspects actually amounts to the whole of contract law. So by just looking at the definition under section 10, it will actually give you the elements that are covered under the whole of contract law. And each of them is a vital element which is looked at independently, and it has its own rules governing it. But let's do a close examination of section 10 just a little bit more carefully. We said that a contract is an agreement, okay, made with the free consent of parties. So free consent is the first vital element of a contract, with capacity to contract. So meaning that parties must have the capacity to contract. Number 3, for a lawful consideration. Consideration here, in essence, it means money, that there has to be an exchange of money, okay, or money's worth. Then number 4, with a lawful object. So the objects of the contract between the parties must be lawful. This is really very important. And then lastly, with the intention to be legally bound, meaning that there cannot be a valid contract if the parties do not have the intention to be legally bound, meaning that parties must have intended to enter this contract, and they must have intended for them to be bound by the agreement or by the contract that they are entering. So basically, that's the definition of a contract under section 10. And also there are really so many definitions. There's one by Professor Pullock in his book Principles of Contract Law 1876. He basically, Professor attempted to define a contract as a promise or a set of promises that the law will enforce. Okay, so there are a number of definitions, but the most authoritative and best definition is under section 10, subsection 1. So having looked at what amounts to a contract by way of definition, let's now proceed to look at the essentials of a valid contract. So what are those important aspects, the ingredients, the elements that must be present for us to say that indeed there is a valid contract? So number 1, there has to be offer and acceptance. Okay. Number 2, there has to be a lawful consideration. We already said that consideration means money or money's worth. But that's not enough. The objects must also be lawful, the objects of the contract. We'll be looking at the objects later on a little bit more in detail. Number 3 is the free consent. So there has to be that free consent of parties. There must not be force, duress, misrepresentation, all those aspects. Then number 4 is the intention to create legal relations. Parties must have intended, okay? That is what is known as consensus ad idem, that the parties must have been in their free state and free mind. They intended to enter a valid contract. Then finally is what we call contractual capacity. So contracts have to be entered in by persons who are sane, meaning that people who are insane do not enter contracts because there is that lack of consensus ad idem. They are not in their proper mental state, and therefore they cannot be said to contract. Also, contractual capacity also connotes to aspects such as age. You must be of majority age. For example, a child who is 6-7 years cannot be said to enter a contract. So basically, those are the essentials of a contract in summary. But specifically for this class, what we are going to be looking at is offer. Okay, we want to unpack that one element of a contract known as offer. And please check out already on this class, there are other classes on acceptance in detail and the rules governing acceptance. There's already a class on this channel on consideration, the rules governing consideration. But here in this class specifically, we're going to be looking at offer in detail. So let's now proceed to define what amounts to an offer. And again, for purposes of definition, I encourage you to look at section 2 of the Contracts Act. It is very authoritative in the definition section, which basically defines an offer as the willingness to do or to abstain from doing anything signified by a person. So that's how section 2 actually attempts to define an offer. Okay, please refer to that definition. It's authoritative, and read it in material detail. Of course, the person makes that offer with a view of obtaining the assent of the other person to the act or abstinence. So basically, an offer is the usual thing which you keep on doing every day. For example, if you're selling your pen, you offer it to Jen. You say, Jen, I'm offering to sell you this pen at 300,000 or at whatever amount. Okay, so that is basically what would amount to an offer. Now, important to note also, under section 3, subsection 1 of the Contracts Act, an offer can either be done by an action. You can make an action to make an offer. For example, if you say, I'm selling you my pen, okay, that is an action. But you can also carry out an offer through what we call an omission. An omission is the failure or to do something, okay? So by omitting, what we mean, an omission is not doing something, okay? An omission is more like the opposite of an act. So an action, you're taking a positive step, whereas for an omission, you're actually taking a negative step, okay? So basically that is it. So an offer can be made through an act or omission. Then also when you read under section 4, it actually provides that communication of an offer is complete when it comes to the knowledge of the offeree. Very, very important to note. So the communication of an offer, this is a fundamental principle. It is complete when it comes to the knowledge of the person to whom it's made. So the moment I say I'm offering you my pen at 200 shillings, for example, to buy it at 200 shillings, that offer is complete the moment you, the receiver, or the person who I'm offering the offer, comes to know about it. Then communication would be complete. So let's now proceed to look at, because we have already defined what amounts to an offer. So let's now look at what you may call the rules, okay, governing an offer. So what are these rules really? When we are talking about the rules governing an offer, okay, what do we mean? Because you have to understand that an offer works within certain rules. There are rules governing an offer. If you're going to make an offer, we weigh it, okay, dependent on the legal rules. So this is what we are going to look at, rules governing an offer. Number 1 is the offer must be communicated to the offeree. So that's rule number 1, meaning that we can't say that there is an offer made if you don't communicate it to the other party. Please, I invite you to look at the case of Fitch versus Sudeka. And in that case, court held that a person can only accept an offer which he is aware of. So if you're not aware of an offer, you can't accept it because in the first place, you didn't know. The second rule governing an offer is that the offer must be clear or certain. Very, very important. So every time you're making an offer to sell something, you always have to ensure that it's clear, it is certain, okay? There are no gray areas, there are no ambiguities. So for purposes of that rule, I encourage you to look at the case of Guthing versus Lin. It is authoritative. It's a case of 1831, 2B and AD 232. That's basically a law report and the citation and the year and the page. So the facts of this case are that during the sale of a horse, so there was one party who was selling a horse, a promise was also made to pay an extra £5, okay, if the horse was lucky, in quotation. So this person went on to say that I'll pay you an extra £5 if the horse is lucky. Court held that this could not be an offer as it was too vague and uncertain, because if you say if the horse is lucky, what do you really mean? How do we even measure that the horse has been lucky as a basis for you to add me the £5? So such an offer, court held, was unclear and uncertain, and as such, court concluded that there was no valid offer. Please distinguish this Guthing versus Lin to the scenario that happened, or to the facts in Khalil versus Carbolic Smokeball. Because in Khalil versus Carbolic Smokeball, court held that the deposit, okay, of £1,000 was not a puff, but it was a serious, clear offer. So please distinguish these two, and that's why I'm bringing in this case of Khalil versus Carbolic Smokeball at this point, so that you're able to distinguish between just an offer which is not clear and a mere puff. Okay, so in Khalil versus Carbolic Smokeball, the offer was clear. Okay, it wasn't a puff, and that's why court went on to enforce it. Please, I also encourage you to learn the technique of distinguishing cases. It really earns you so many marks. So you have to show the examiner that you're able, or you have the skill to distinguish facts of certain cases or facts of a certain case from another case, and you draw yourself to a conclusion which is correct. That skill really is very, very important, and you'll always be awarded highly for the same. So let's now proceed to look at the third rule. And basically this is that there must be knowledge of the offer. So there has to be knowledge of the offer, meaning that the other person must come into knowledge about that offer. Again, authority, I encourage you to look at the case of Fitch versus Snedeker. It's very authoritative. I already shared with you the citation and the facts, so please just refer to it. So basically, ladies and gentlemen, those are the rules governing an offer. Let's now proceed to look at another aspect, and that basically are the rules governing revocation of an offer. Okay, so if an offer is going to be revoked, if someone makes an offer to you, but you want to revoke it, to cancel it, okay, to take it back, what are those rules governing revocation of an offer? So we are going to look at them in material detail. Please look at section 10, or rather look at section 4, subsection 3 of the Contracts Act. It actually lays down all those rules governing the revocation of an offer. But we are going to run through them so that I'm able to throw more light on the same. So refer to section 4, subsection 3 of the Contracts Act of 2010. It is authoritative on these rules governing revocation of an offer. So let's start with section 4, subsection 3A. And basically that section provides that communication of a revocation is complete as against the person who makes it, okay, when it's put into the course of transmission to the person to whom it's made, so as to be out of the power of the person who makes it. So basically the first rule here is that communication of revocation, okay, is complete to the sender when he or she puts it into transmission to the receiver. That is basically section 4, subsection 3A summarized. And that indeed is the first rule. Let's now go to the second rule, and this is under section 4, subsection 3B, which basically provides that communication of a revocation is complete as against the offeree, okay, when it comes to his or her knowledge. So in essence here, what we mean is that communication of revocation is complete to the receiver when it comes to his or her knowledge. So meaning that if you revoke a contract and then you communicate it to the other person, the communication of revocation is complete the moment the other person gets to know about it. Meaning that if they never get to know about it, then there cannot be complete revocation of an offer. Very, very important to note. Let's now proceed and we'll look at the third rule governing revocation of an offer. The third rule is actually under section 5, subsection 1. Please go and look at that section. But in summary, it provides that revocation of an offer may be at any time before the communication of its acceptance is complete. Very, very important, meaning that you can revoke an offer at any time before the other party actually accepts it. Okay, that's also another rule. For purposes of that rule, I encourage you to look at the case of Rutledge versus Grant. It's a case of 1828. 4 being 653. Again, that's a law report, the year and the page. But the brief facts of this case are that Grant offered his house for sale on ground that it would remain open for 6 weeks only. So he made an offer that he's selling his house, but however, he went on to put a condition saying that my offer is only valid for 6 weeks. Now, he then took the house off the market, of course, before the end of the 6 weeks. Court held that there was no acceptance at the time of withdrawal. His actions were legal. Because you see, there's a party who went on to accept the offer, but that was after he had actually withdrew it. And there was, of course, disagreement. They ended up in court, and court said that actually revoking that offer was within the legal parameters, because at the time of revoking his offer, there was no person that had accepted the offer as yet. However, here what you should note is that under unilateral contracts, revocation of an offer will not apply where the offeree continues to perform acceptance. For example, I already shared with you the case of Khalil versus Carbolic Smoke Ball, a case of 1893, volume 1, QB, page 256. And basically in this case, please, I encourage you to read that case in material detail. It's very, very important. It's a locus classicus on contract law. Please ensure that you read the whole of it in material detail. So basically, when there is a unilateral, if there is a unilateral contract, there can't be revocation of an offer where the offeree continues to perform the acceptance. Like you see in Khalil versus Carbolic Smoke Ball, already the other party had actually taken the medicine. So if, let's say, the company had attempted to say that we are revoking the offer when already the other person is already putting it into play, then such revocation cannot be said to be valid. So please distinguish the facts of Khalil versus Carbolic Smoke Ball from Rutledge versus Grant. Very, very, very important. So basically, those are the rules governing revocation of an offer. Let's now proceed in the last segment of our class to look at another aspect, and that is what we call termination of an offer, or also known as the modes of terminating an offer. So if there is already an offer, what are some of the modes, or you can call them the ways of how an offer can be terminated? This is what we are going to look at in material detail. So termination of an offer, or the modes of revocation of an offer, are as follows. The first mode, actually these modes are provided for both under statute and common law, but the first mode is basically under section 6, subsection A of the Contracts Act. And basically the first mode is by revocation on notice to the other party before acceptance. So that's one mode, and in summary, this is by notice. So you basically inform the other person that you're going to revoke your offer, but that's only before they accept. So meaning that you can't revoke an offer where the other person has already accepted. If you do so, then the same would amount to breach of a contract. Please, I encourage you to look at the case of Rutledge versus Grant. I shared with you the full citation and the facts of that case. But briefly, Grant offered to sell his house and leave. Okay, he left the offer open for 6 months. Well, in his offer, he had said he would leave it open for 6 months. But however, he took back the house before, it was actually 6 weeks, not 6 months. But however, he took back the house before 6 weeks. So court held that his actions were legitimate. Why? Because he revoked the offer before it was actually accepted. Let's now proceed to look at the second mode of revocation, and this is under section 6B of the Contracts Act, and that is basically a lapse of time that has been prescribed by the offerer in the offer, or a reasonable time if no time is prescribed. So the other mode of how an offer can be terminated is through lapse of time. Okay, very, very important. Authority for that position, please look at the case of East African Industries Limited versus Polsland. The brief facts of this case are that the plaintiffs advertised for tenders to supply grain on 10th August. Acceptance was communicated on 25th September. That was after a few months, really. Okay. The defendants refused to supply the grains, alleging that the delay was unreasonable, and court accepted. Okay. So basically, a lapse of time. If an offer is met, maybe someone says, I'm offering to sell you my pen within 3 hours. If the 3 hours expire and you accept such an offer, then the offer would have terminated. Okay, so the offer would have been revoked due to lapse of time. But what happens in a situation where a person makes an offer to you, but they don't attach any time? So if someone says, I'm offering to sell you my pen, that offer is made on 1st January, let's say. If you accept on March 1st, okay, or let's say after some months, can that be said to be a reasonable time? The answer is no. Court will hold, or court will find that actually the offer lapsed, even if the other person did not actually attach a timeline. But if I offer to sell you my pen, let's on Monday, and you accepted on Tuesday, one day, okay, in my view, all factors constant, would be a reasonable time. So the other party cannot allege that actually the offer had been terminated. So let's now proceed to look at the third mode of termination of an offer. And basically, this is under Section 6, subsection C of the Contracts Act 2010, and that is the failure of the acceptor to fulfill a condition precedent. So I can give an offer to you, but it has a condition. Okay, I'm telling you that I will sell you my pen, but that's if you first maybe do something. Okay, so if you don't do that something, then my offer would have terminated. That's what we call a condition precedent. It's a condition that I have attached to an offer, which you're supposed to do first before you actually accept or take on the offer. Authority for that position, I encourage you to look at the case of Financings Limited versus Stimson. It's a case of 1962, Volume 3, All England Reports, page 386. Please look at it. Now, the brief facts are that this involved the purchase of a car. A condition implied by law was that the car would remain in the same condition from the time of offer up to acceptance. Now, unfortunately, the car was stolen from the showroom before conclusion of the contract, and court held that the purchaser was not bound by the agreement. Okay, why? Because there was a condition precedent that the car had to remain in the showroom. Unfortunately, it was stolen, so meaning that the condition was never fulfilled, and as such, the offer had been revoked. Let's now proceed to look at another mode of termination of an offer, and that is under Section 6D of the Contracts Act, and that is basically the death or insanity of the offerer. So if the person who makes the offer actually dies, or they become insane, then that's a quick way of terminating or bringing to an end the offer that they made, because they have died. So meaning that you cannot enforce against someone who is dead in terms of the offer. Please, I encourage you to look at the case of Reynolds versus Atherton. It's authoritative. It's a case of 1921, 125 LT, page 690. Please look up the facts of that case and the holding. It's very authoritative. Let's now proceed to look at the second last mode, and that is rejection of the offer. So, of course, an offer can also come to an end by way of rejection. If I offer you my pen at 200 shillings, if you say no or you're not interested, that would amount to rejection of the offer. So an offer can actually come to an end if you actually reject it. That's one of the modes. Authority for that position, please look at the case of Hyde versus Range. It's very authoritative. I already shared with you the citation of the case. But in summary, court held that no contract existed in the facts of that case. Why? Because by his letter of 8th June, the plaintiff rejected the original offer and couldn't revive it by changing his mind and accepting later. His counter offer eliminated the initial offer. So the facts here were that an offer was made to this gentleman. He rejected the offer, and then after some time, he went on to accept the offer. Court held that there was no offer to accept because there was a rejection, and a counter offer eliminated the initial offer that was actually made by the seller. So rejection of an offer is surely a quick way of revoking an offer that is made by the other party. Finally, ladies and gentlemen, the other last mode of terminating an offer is by a counter offer. Okay, so a counter offer to an offer actually rejects the initial offer. So assuming I say to you that I want to sell you my pen at 200 shillings, and you say that I'm actually offering to buy it at 100 shillings, your statement, okay, would actually be a counter offer to my offer, and meaning that it takes away my initial offer to sell you at 200. So assuming you turned around after a few seconds and said, okay, I accept to buy your pen at 200 shillings, that would not be an effective acceptance. Why? Because you first made a counter offer which took away my first offer, and therefore if you come back later to accept my offer, there would be no offer to accept because you took it away by making a counter offer. So meaning that when you make a counter offer, it now comes back to me to either accept the counter offer or to reject it. Okay, so please, again, authority for that position, look at the case of Hyde versus Wrench. I already shared with you the facts and the citation of that case. It's also authoritative on the mode of counter offer as a way of actually terminating an offer. So basically, ladies and gentlemen, that is all we had to cover for our class. We have looked at offer in material detail. And again, please, if you've not yet subscribed to my channel, subscribe to this channel, turn on the notification so that every time I release videos, this is brought to your attention. This is really important so that you don't miss any classes. And also give our videos a thumbs up, like them, and also share them with your colleagues so that your colleagues are also able to benefit from this wise knowledge. Because if I hadn't shared with you, you would never have learned this. So please do not deny your friends the opportunity to also learn. Share this video with all your friends and colleagues so they can also benefit. And then finally, before we come to the end of our class, if you need any help, any legal help, please contact us for private law tutorial sessions. Our numbers are already down in the description box, so you can WhatsApp us, you can contact us, call us. We'll be able to help you. We can always organize the private law tutorial sessions at your campus, at your office, or anywhere privately in your holidays, or any time that is convenient for the both of us. So contact us. Our numbers are down in the description box. We'll be able to help you because these private law tutorial sessions have been proven to work, and students who do not have any sort of mentorship have been continuously shown not to perform well. And of course, those with mentorship will always outperform their colleagues. So please contact us. We'll be able to help you. Please check out the other classes on this channel. There are so many on acceptance, consideration, and other legal concepts. Thank you. We meet in another class. Bye-bye.